Yeah, thank you so much. And it's thank you so much for having me here. And yeah, so I guess the sort of structure here is first I want to talk about why raise capital, why syndicate apartments, or why syndicate real estate in general. It doesn't just have to be apartments, but whatever asset class you're into. So first I want to talk about, the benefits of that. Then we're going to go into the laws around raising capital, how to stay compliant. Then we're going to go through a little bit of deal structuring. And then next week, what I'd like to do is I've developed sort of a process in my legal, in my practice to really help efficiently, provide the legal services, the legal documents for my clients. So we're going to go through that system next week, and hopefully you guys get a lot of value out of that. But so I know we're limited on time and we got a lot to cover. So I'm just going to share my screen real quick. And what I want to go through now is I'm sure a lot of you on here have a lot of experience or varying experience in real estate. And the first question, I remember, I forget how many years ago now it was, but before I went to law school, I remember thinking, like, I was working at this job that I didn't like. It was kind of a dead end job. Um, and I was just thinking, man, I don't know how to ever like get out of this sort of rat race, right? And then I ended up reading a book called Rich Dad Poor Dad, which I'm sure a lot of you guys have heard about. And I read that book and I realized, oh my gosh, there's a way to passively earn an income. And real estate just became that path. And so I really wanted to pursue real estate. And even while I was going into law school, I thought, man, I'm not gonna practice law. I'm just gonna focus on real estate. And then I started wholesaling while I was in law school, and I was doing pretty good. But I remember sitting down with one of my mentors, and he said, when you're in real estate, think about your goals as far as why you're in real estate, and always work towards those goals. So why are you doing this? And at the time, the reason was because I wanted a passive income so I could quit any kind of W-2. At the time I was in law school, so I didn't have a long-term job, but I also didn't want to graduate law school and get into a long-term W-2 job that I didn't like. So I thought, man, I'm just gonna get into real estate, get the passive income. And then he was like, okay, so if you're gonna get the passive income, how much do you need in order for you to say, okay, I can quit, I can retire off of this? And so my goal was, I think at the time, $60,000. If I can get $60,000 in passive income, I would be good. And so we started going, we were wholesaling houses together, flipping a couple houses. And I just realized how long, even with making those pretty decent sized clips in wholesaling houses, how long it would take me to buy that house, or to buy enough houses to hit 60K in passive income. And so when I was thinking about how to expand this, I came across the word syndication. And at the time I didn't know what it was, even though in law school we had talked about securities laws and all this other stuff. Syndication did not come to my, it was not a part of my my awareness. And so when I came across this term, I learned that it was just one of those ways that you can you can really scale up a business. Instead of buying one house at a time, you can buy just a chunk of properties at a time, or maybe even one apartment at a time, and really solve a lot of those cash flow problems. But of course, buying those bigger projects required more money that I didn't have. And so syndication became this way, at least for me, to quickly solve that cash flow problem. But no matter where you are, it is potentially a way to increase, to scale your business and to increase leverage. It's kind of like if you guys have ever done stock trading, when you have leverage, if it's you say 100-to-1 leverage, any dollar that you make $100, right? And of course, the downside is if you lose a dollar, you lose 100. But in real estate, you can also leverage you pull a lot of levers in order to increase your ROI. And one of those levers is obviously debt, but another one of those is other people's equity, other people's money. And so this just became a really exciting area of law where it just opened up so many opportunities to accomplish your goals. But it's so important, it became so important for me to learn how to do that and how to help other people do that. And so that's really my focus right now in my law, in my practice of law, which is just I want to help people raise capital and really meet their financial goals through raising capital. And so I wanted to walk through a quick a video, because we're going to get into the laws, and that part unfortunately can be kind of boring. I mean, it's now fun for me, but even when I first started getting into it and start trying to figure it out, it was very tedious, it was very difficult. But but the legal part can be kind of boring. So I definitely want to show sort of the benefit of raising capital using other people's money. So I've got a financial model that I set up a template deal. Anyway, so this is one of my financial models that I use, and I've just highlighted all the areas that we're going to go through, because I don't want to take up too much time going through all of this. So let's say you find an apartment, it's a 40 unit, the purchase price is $7 million. And in a syndication, in a syndication or a fund, and I use those two terms kind of interchangeably, but a syndication is basically raising other people's money to purchase an asset. And usually when I use the term syndication, this isn't the way everybody uses it, but when I use the term syndication, I usually mean an identified asset that you've already got under contract or something like that, versus a fund where you might just have a deal criteria, and you use other people's money to go find those deals. So so I use those two terms differently, but in this case, this is a syndication, and in a syndication, as a sponsor, you can charge several fees to your investors, right? One of those fees is an acquisition fee, and that can be anywhere from 1 to 4%. Anything over 4% is on the high end, but I have seen higher acquisition fees. You can also charge construction management fees. For example, if you're doing a lot of rehab, you can charge those, charge construction management fees. I typically see anything from 6 to 8. In this, for purposes of this walkthrough, I'm not going to charge, or I'm not going to get into the construction piece of this. But again, if you do have a heavy lift, you can also charge construction management fees. You can also charge refinance fees. And again, those are typically between 1 and 2%. And then disposition fee, which is basically, on the sale of the property. And then you can really charge whatever fees you want to. We obviously want to disclose that to investors, but I'm just going to show you how those fees, and along with your share of the profits, can really, can be life changing, right? So assume that you buy this property for $7 million, and you're going to hold it for 5 years. And the split that you're going to give your investors is 7% preferred return. And a preferred return is sort of, for lack of a better term, it's sort of like an interest rate that you pay your investors. And I say it's sort of like an interest rate because it's not, an interest rate is something that's required to be paid. A preferred return is just something that investors get before anybody else. It's just a priority return that they get. But if you don't have enough cash flow to satisfy that preferred return, then they don't get paid. They don't get that. They don't get that paid to them. So the preferred return can be anywhere from usually 6 to 10% is typically what I see. But you can also not give a preferred return if you don't want to. But in my scenario, I'm going to give 7% preferred return. The investors are going to get the 70% of all profits of all cash flow, and they're going to get, and you as the sponsor are going to get 30%. So we have the revenue tab where I put in the revenue. Again, it's not super important. And then I've got we got the appreciation in market rent growth over here. So we're assuming that it's, the market's appreciating 3-4%. And so if you go to the annual cash flow, you see that you're cash flowing in year one. And again, this is just a sample deal. So it's not, so take this for what it is. But after debt service and everything, you have $216,000 left over in my hypothetical example. So we go to the waterfall and we see how that is divided, and you can see how much your investors are going to get. Your investors in this hypothetical deal invest, so you need to raise about $2.5 million, and they get their preferred return of $172,000 a year, plus the excess cash flow after they hit their preferred return. They get 70% of the cash flow. You get $32,000, which doesn't seem like, that doesn't seem like a lot, but this is just one deal, versus doing multiple deals where for me, I needed to do I think at the time when I was calculating how much I needed to make $60,000 in passive income, I needed something like 20 or 30 houses. I forget what the number was at the time, but that took a lot of work, and you had to do all the due diligence for each individual property. But in this case, just one 40-unit deal could get you halfway there. Plus that acquisition fee that you get at the front end, you're making $210,000 of that. There's a book out there called The Best Ever Syndication by Joe Fairless, or The Best Ever Syndication book by Joe Fairless. And he suggests, he says, when you're, because you're doing a lot of work for, to raise capital, to find these deals, to due diligence them, to do all this stuff to close this deal. So you should get paid for that. And so he actually recommends focusing, when you're first starting out in syndications, to focus on the acquisition fee, because you can literally, essentially feed your family just with the acquisition fee, and that can hold you over till the next deal, right? Or to get you through the first deal and then hold you over to the next deal. But on the acquisition alone, you're making $210,000, and then you're making $30,000 in year one passively. Again, hypothetical deal, but this is just what's possible. And then in year four, thanks to appreciating rent growth, you can make up to $60,000. And then in year five, when you sell the deal, you're exiting with $752,000. And that's just on exit, right? But you also made all this other money along the way. And so, the other nice thing about it is, as you start to scale, let's say that you wanted to, well, let me go back to this. So the total profits that you would make as a sponsor could be $1.1 million over the course of 5 years. And, that's, for some people, depending on your on where you are in real estate, that number is not that big anymore. But for people who are new to this can be life-changing money. And the nice thing is if you did 5 deals a year, or if you did 1 deal a year, that's over $5 million that you have at the end of the deal cycles. And so it's game changing. And if you wanted to make more faster, you can just maybe scale up the size of your offering, or the size of the deals that you go after, right? So let's say that you go after instead of 40-unit deals, maybe you go after 80-unit deals. And as you can see here, your profits from that would be almost $2.3 million just by going after a bigger deal. So for me, real estate syndication and funds are one of the best ways to scale your business and to hit your financial goals a lot faster. But in order to hit those goals, there are some things that you have to know, and the main things are going to be regarding compliance with the SEC. And so, as for me, I'm a securities attorney, so obviously I focus on SEC compliance, but also I like to think that I help people from a legal perspective also manage their funds, manage their businesses from a legal perspective. So it's not just SEC compliance, but it's the whole operating your company, operating your business, operating your fund in an efficient manner that's also protective for you, but also your investors. Excuse me. So in order to begin syndicating real estate, you have to be aware of some of the laws, and some of you might be aware of them already. I know there was another attorney on here a few weeks ago who spoke about this. But I just want to build out a framework so that when you guys start going and raising capital, or even start considering raising capital for your deals, you can just have an understanding of the laws that are implicated when you're doing that. And so my goal is to sort of just present a general framework, and then anytime you have a question, or anytime you come across a situation, hopefully my goal is that you have sort of just a mental framework for you to plug in that question and say, okay, this issue belongs here. How do I deal with it, right? Or who do I need to talk to help me deal with it? So I'm just going to go through this deck real quick. So the first question is, what is a security? I mentioned that I'm a securities attorney, but what is a security? And the SEC, if you look at the rules regarding securities laws, they just have a laundry list of things that they say is a security. But a lot of people, what people started to do is they started to develop these instruments to try and get around that laundry list. And so so one of those cases went to the Supreme Court, and the SEC basically came up with a test to say, okay, if you meet these requirements or if you meet these factors, you sold a security, even if it's not in the definition of the Securities Act. You're selling a security if if you meet these these criteria. And those three criteria are right here. Are you raising capital from passive investors? And those passive investors, well, let me finish that. So, are you raising from passive investors? Are they expecting a return of any kind? And will those returns be based off your efforts? And if the answer to all three of those is yes, then you likely have a security. There's some exceptions, but very few, and most of those are case by case specific. So the SEC has already said, hey, one of those things that is a security is an interest in an LLC or a share of an LLC. Because when you go to raise capital, you're going to say, hey, investors, you give me money, and in exchange, I'm going to give you a piece of my company. And that piece of a company, usually called a share or an interest, that is considered a security if capital is being exchanged for that share. And so a lot of people think that there's different exceptions. For example, I was actually at a conference a few months ago now, and it was on single family. It was a guy teaching about how to raise capital for single family properties. And he said, hey, if you structure it like this is not a security because it's such a small deal and it's only one investor, and one investor, one house. It's not a security. That's not the way it works. I didn't, I'm not there. I wasn't there to enforce the law. So I didn't, it wasn't my place to say anything to him on stage, but that's not the case. It doesn't matter how small the deal is. Doesn't matter how big the deal is. Doesn't matter how many investors there are. So really, there's three ways that you can handle a securities issue. And the best way, the cheapest way, is to avoid its implications. As Chris pointed out, if you're trying to avoid saying, hey, I have a security, then everybody who is participating in that project, whatever that project might be, has to have an active role. And that active role has to be significant in a way that if the SEC was to ever investigate, the SEC can come to the conclusion, yes, everybody is active, therefore there is no security. So that's the best way to do that is avoid the implications. And we're going to go through all the securities laws and discuss how to avoid the implications. The second option is if you have a security, right? You can't avoid the implications. You have a security. You have to register it with the SEC. And that could take up to 2 years. It could cost, I've heard, up to $1 million, maybe even more. Because at that point you're essentially going public. We have these three factors here these three things that the SEC will look at. Are you raising capital for passive investors? Will they be expecting a return based off your efforts? If yes, then you have security. So this is the next slide I was on, which was how to deal with the securities law. And there's four main securities laws. And again, it's always, can you avoid the implication of any or all of those securities laws? If no, then you got to register with the SEC. But that's not ideal because it's so expensive, can be so time consuming. So ideally, we want to find an exemption. If we can't avoid the implication, we want to find an exemption to registering under the securities laws. So the first one is the Securities Act of 1933. And the sort of abridged version is that it's unlawful to offer or sell a security. And whenever I say a security, just think it's unlawful to raise capital in my LLC or in my entity. It's unlawful to exchange ownership for capital, right? So it's unlawful to sell a security without registering with the SEC unless it's exempt from registration. And so how to avoid the implication? Because again, that's going to be the cheapest and easiest. Well, I wouldn't say easiest. It's going to be the cheapest route and the fastest, is just to avoid the securities law or any of the securities laws. And so structure it so the options are structure it so that it's not a security. And how do you structure that? Well, ensure all the partners are going to be active in the deal. So if you're going to raise capital from your rich uncle to go flip this house, that uncle needs to do something significant to ensure that he is active in that role. Now, the problem with ensuring all partners are active is that the SEC applies a facts and circumstances analysis on a case-by-case basis. So without knowing exactly how the SEC is going to rule, it is sometimes difficult to know how much activity is enough to ensure you are, you don't have a security, to ensure that all your partners have an active role. So that can be difficult, but a lot of joint venture deals are structured this way, where maybe one person has the financial background, the other person has the development background, and so they make a good partnership, and they both have money. They come together and they work on a project. That would be a good example where a security does not exist, and so we don't have to worry about all the other laws. But usually, if you're raising capital from passive investors, and even if you want to structure it so it's not a security, it could be very difficult to say, okay, even though you intended to be passive investor, now you got to be active so we don't trip up these securities acts. That could just be a very difficult, that could just be a very gray area to try and figure out. So the other ways to do that, or the other ways to deal with this law, is to use an exemption from registration. So let's say you can't avoid the implication of the securities laws. You're doing a $10 million deal, and at least some of your investors are going to be passive. So you can't avoid the implication of securities law. So you have to find an exemption. There's a lot of different exemptions. I'm sure you've heard of Reg A, Reg CF, Reg D, Rule 504. But the most common, I think, I think I read recently, almost $13 trillion have been raised under Reg D, 506B, and 506C, versus I think it's only been a couple $1 billion under these other regulations combined. So Reg D is by far the most common one to use when you're raising money in the private markets. And so Reg D, Rule 506B, I'm sure some of you guys have heard about this, but it allows you to raise unlimited amount of money. You can have up to 2,000 accredited investors, and once you get over 2,000 accredited investors, the law basically treats you as essentially a public company, and therefore it requires you to make additional disclosures and all this other stuff. And so, so you can have up to 2,000 accredited investors and up to 35 non-accredited investors. And actually, I should say, total investors you can have is 2,000. Is 2,000. So between the non-accredited and accredited investors. Accredited investors, for those who aren't familiar with the term, just means high net worth individuals, people who have over $1 million of net worth, or if they're, depending on if they're individuals or jointly owning the shares, they have to have either $200,000 or $300,000 of yearly income. But you can't advertise. You cannot advertise under Rule 506B. You have to have what's called a pre-existing relationship with all your investors. But the nice thing is you can self-certify. So in other words, if a non-accredited investor says, hey, yes, I'm not accredited, you can have your accredited investor say, yes, I am accredited. And you can take that as, you can rely on that, their self-certification. Whereas in Reg D, in Reg D, it's a similar situation. But you can advertise, but you have to take reasonable steps to verify that they are accredited. And so when I say you can advertise, it means you can go out on social media, blast that you have a deal going on. You can do Google ads or however you want to advertise to bring in investors. You can do that under Rule 506C. And these can be very nuanced. I mean, I've been doing this for a little bit now, and I've just seen so many different variations of when you can't advertise under 506B and what advertising looks like. I don't want to get into all of that because, again, it's sometimes very case by case specific. But just generally, you can't advertise if you're gonna be raising under 506B. So what a lot of people do, and this is something really cool that I've really, it was kind of surprising that the SEC did this, but about 3 years ago, you weren't allowed to go from a 506B to a 506C. In other words, you weren't allowed to rely on the rule. Let's say you were buying a real estate project, and you had your friends and family who weren't accredited, and you wanted to bring them into the deal, but you also needed to advertise in order to get some more investors into the deal, in order for you to close that project. You used to either have to choose 506B to let your friends and family in, or 506C. You couldn't use both, because the SEC would essentially, if it's for the same project, they would integrate that. Most recently, the SEC has actually gone back on that and said, hey, you can actually go from a 506B to a 506C. However, you need to basically cease all activity under 506B and then commence under 506C in order to not be integrated. And so that's a really good option for people who say, hey, I do want to bring in some friends and family, but I also need to advertise, right? So how we would structure that is we would raise the capital under Rule 506B, close that offering, and then do a new offering under 506C. But the nice thing is too that the SEC doesn't require new offering materials, so you don't have to create all new documents for the new offering. So it actually saves a lot of time and a lot of money as well. So the other things that you have to know about this is that this is where the other requirements are that you do have to provide all material disclosures to your investors, and this is where you get the PPM and the subscription agreement, operating agreement. So if you've ever engaged with a securities attorney, usually they all have the operating agreement in it. 506B is actually, or I should say, if you have been raising capital before, doing all this stuff, before learning about this, my hope is that at least you used accredited investors. And I say that because under these rules, you also have to provide certain disclosures, and the disclosure requirements are a lot more stringent if you have even one accredited investor. The SEC basically says, hey, if you have one non-accredited investor, you have to provide all these disclosures. Whereas if you have just accredited investors, there's less stringent requirements. And so ideally, if you've done this before without going through all these steps, ideally, you would have accredited investors. And I know I saw Patrick Sugar on here, who's one of my mentors in this practice. And his advice is that if you can use only accredited investors, that would be ideal. But obviously sometimes that's not possible, but that is kind of a benefit, it is preferred if it can be helped. So basically, we definitely want to make sure that we have the disclosure requirements. Again, that's where the PPM comes into play. And the PPM kind of acts as an insurance policy, because if an investor can ever come up to you and say, hey, I wouldn't have invested, whether they're accredited or not accredited, if they said, hey, I wouldn't have invested had I known this, then you can either have an issue with the SEC. They can go to the SEC and file a complaint, or they can file a civil complaint. And so either way, you don't want to get wrapped up in that. So the PPM kind of acts as an insurance policy that says, hey, here's everything that could go wrong. You sign agreeing that you understand that everything could go wrong. And so basically, if you come back and say, hey, I would have invested had I known this, you can say, hey, we disclosed that to you. We told you that could happen. This is no longer on us. It's on you. And so, but yeah, you definitely want to make sure those disclosure requirements are met. The next act is the Securities and Exchange Act of 1934. And basically, this is where, Chris, I think you were asking, is what kind of license do I need to raise capital? And the answer is you need to be a registered broker-dealer. And broker-dealers fall under FINRA law. So not only do you have to register under the SEC and follow all their requirements, but FINRA has a whole separate list of requirements that can just get very expensive, very difficult to follow, and very time consuming as well. And it, in some ways, especially if your focus is on real estate, it can just not be worth it, potentially, depending on your situation. It may not be worth going through all the trouble of registering as a broker dealer. But the SEC also provides an exemption from being a broker dealer, which is if you are, well, actually, sorry, let me get through this slide. A lot of people in their deals, they use, in this space, at least, I don't know if you've heard this before, but in this space, they call them capital raisers, right? Or they'll call them co-GPs or something like that. And what they mean is, if you find a deal, you may not have the capital connections. And so you bring in people who do have capital connections. And what you do, what a lot of people have done, is they'll make them part of the management team, and give them a piece of the management's pie, in order to incentivize them to come into the deal and bring their investors. The problem is that the SEC literally says, hey, you can't do that unless you're a broker dealer. And on their website, they even said, what is a broker dealer? It's any individuals or entities that are engaged in finding investors for issuers. And the issuer, by the way, would be your entity that's purchasing the project or raising capital. So they said, hey, if you're engaged in finding investors for issuers, you're a broker dealer and you need to register. Or it's persons they specifically say this: persons that market real estate investment interests. That includes your shares in your LLC that's purchasing the property. So these people are broker dealers. And so the issue, and by the way, you as a sponsor, even though you're managing the deal, you would also be considered a broker dealer. So the SEC came up with an exemption, and it's called the associated person of the issuer exemption. It's not a very it's kind of a mouthful, but basically they say that if you're associated with the issuer, you can be exempt from this from registering as a broker dealer if you meet all these requirements. You can't be a bad actor. In other words, you couldn't have been accused of a financial crime. You can't receive special compensation or commission for selling securities. What this means is the SEC calls it transactions-based compensation. You cannot take commission, you cannot take compensation equal to how much capital you raised. I see this a lot, unfortunately, where people say, okay, if you bring in 10% of the capital, I'll give you 10% of what they call the GP. I'll give you 10% of the management company. And that's a very obvious red flag. And then they also say that one of the other requirements is that you also have to perform significant duties for the issuer after completing the offering, and your compensation has to be commensurate with the work that you do. And so going back to this, and there's these other requirements, but the SEC has said, of all the requirements, some of them, if you fail to meet one, it won't bar you from this exemption. But these two in the middle are ones that if you do fail to meet these requirements, then you will most likely be seen as a broker dealer, an unlicensed broker dealer. And so a lot of people, what they do is going back to that co-GP situation where they say, hey, if you're buying the property, I don't have the capital connections. I know somebody who has the capital connections. I'm just going to bring them in and give them a significant role. The problem is that the SEC is ultimately the one who's going to determine if those roles are significant enough to allow you to use the broker dealer or this exemption. And so it can be kind of difficult to track. There's different situations where we can help develop your operating agreements or develop advisory contracts to make sure that these individuals that you're bringing in are actually going to be performing significant roles. But if the SEC ever does audit you and they see a GP team or a management team that's 15 people long on one real estate project, it might raise some red flags. And so just wanted you guys to be aware of that. And if you guys are considering bringing in sort of capital partners, for lack of a better term, certainly let's talk about it and figure out some strategies for making sure that we comply with this rule. But this is one of the biggest ones, I think, in our space, that if it gets violated the most, this one's probably it. And then the other two, I'm going to talk about these other two, that in syndications, when you're just talking about one project, you typically don't, and I see I'm actually we're coming pretty close. I'll try to wrap up as quickly as I can because we still got to get through the deal structures, but if we have to talk about that next time, we can. But so this isn't a thing that we talk about too much when we're dealing with a specified deal, but oftentimes when you're developing funds, you have to consider the Investment Company Act and the Investment Advisor Act. So basically, what we're here in the Investment Company Act, it says any company that holds itself out as being engaged primarily in the business of investing or reinvesting or trading of securities, you have to register as a investment company. And then the best way to avoid that implication is to just not act as an investment company. I know that's that's sort of circular, but the SEC basically says, hey, if you're operating a deal or if you wholly own subsidiaries that operate a deal specifically, you're an operating company, and therefore you're not an investment company. So that's pretty straightforward in a syndication where you've got a deal identified. You're more likely being an operating company than you're acting as an operating company, not as an investment company. So you can avoid this. It gets trickier when you talk about funds that are going to potentially invest in other people's deals, or fund of funds which specifically invest in other people's deals. So if you ever come across those situations, there's two main exemptions. If you're not going to be considered an operating company, the two exemptions are found in Section 3C1. which basically limits you to 100 investors. But that's not ideal, especially, if you do have a lot more smaller investors that, if you have smaller investors, you're probably going to have a lot more of them in order to reach some financial goal. So you can also rely on, again, in some situations, if you're going to have direct interest in the property, or the same, as the SEC says, the same benefits as a direct interest in real estate, you can rely on 3C 5C, which is a real estate exemption from the Investment Company Act, saying, hey, if you are, again, owning direct interest or get the same benefits as a direct interest in real estate, then you're exempt from the, registering as an investment company. And that's pretty nice because they don't have a limit on the number of investors. And then finally, the Investment Advisor Act, it says anybody who holds themselves out as for compensation is engaged in the business of providing advice to others or issuing reports or analysis of securities. So basically, if you're an investment advisor, you have to register as an investment advisor. But the exemptions, there are, the implications really, again, if you are focused on a specific project, you're likely not giving advice on securities. And the SEC has even said in one of the statements they've issued, that real estate is not a security. So again, if you're purchasing one property and you're saying, hey, investors, come invest in this deal, then you're likely not acting as an investment advisor. But again, if you in a fund-to-fund situation, you definitely have to consider, and I'll go through a fund-to-fund structure, which basically a fund-to-fund structure is where you raise capital in your own deal or in your own business to invest in another business. And there are some complications with that, but if you find yourself in that situation, just a couple of things to remember is that one of the exemptions from registering with the SEC is that you have to have 150 million or less or more in assets under management. And if you don't have that, if you're on the smaller side, you have to look at the state's laws and see what their exemptions are. So it becomes a state by state analysis. But the SEC also has something. They also have an exemption for investors or investment advisors to private funds, where you don't have to do a full registration, but you have to do a partial registration. And so these are often called exempt reporting advisors. And every state, again, also has deals with exempt reporting advisors differently, or investors on private funds differently. And so we're going to go through, and again, mostly when you deal with the Investment Advisor Act, you're mostly dealing with you're mostly dealing with fund of funds, a fund of funds issue. So this is a joint, what I'm calling a joint venture structure, and this is where all the members are active. And again, you have the main sponsor who might have day-to-day management, but the capital partner or this active partner might have a more a less involved role, but they still need to be involved. And again, you create this special purpose entity that'll hold the property, and then everybody just works to make sure that this project is successful. So the laws, so basically, if you're looking at the different laws, right, starting from the Securities Act of 1933 to the Securities and Exchange Act to the Investment Company Act and the Investment Advisor Act, essentially none of those are implicated, because if everybody has an active role, then it's not a security, and therefore we don't have to go into the analysis of all these other rules, right? It's not a security, so you don't have to worry about it. Here's sort of a basic deal structure that how I structure my deals. I was on a phone call with another attorney the other day, and actually yesterday, and we structured deals differently. And so we discussed pros and cons of this, but this is how I typically structure my deal. If you have a property or multiple properties identified, you could own them in this one syndication entity. If you have a fund, if you're going out and buying multiple properties that haven't been identified yet, you might want to create separate what we call SPEs that will own the properties, and the fund will be a wholly owned or will wholly own those other SPs, and the SPs will own the property. But generally speaking, this is the deal structure. We have the syndication entity. I always structure it as a manager managed LLC, and that way we can have a management entity that will manage this company, and it will make all the day-to-day decisions. You and your management team, you guys will be members of this management entity, but you'll also hold and you'll be entitled to those fees that we talked about, right? The acquisition fee, the disposition fee, all that fun stuff. That's the management entity will get that. But if you're doing something like a 70-30 split with investors of cash flow or proceeds out of sale, that 30% promote, or some people call it a carried interest, I call it a promote, or maybe you've heard it called something else, but that 30%, I'm just going to call it a promote. That 30% promote will go to the Class B members. And typically how I recommend is that you have a separate holding company that is a Class B member that you can have your Class B shares held in. And the reason why is because we want to separate out liability between the management entity and the Class B members. Sorry about that. And the reason why is because if the management entity, for example, ever gets sued because they're the ones doing the most work on the deal, then you don't want that 30% promote to be at risk, because that's going to be your biggest chunk of change. So you don't want that to be at risk. So we separate that out by creating a holding entity as a Class B member, and then your management entity is just going to get the fees. So again, if it ever gets sued, then you can always stop paying the fees, but the promote is still protected. However, in that kind of deal where you do have Class A, I forgot to mention the Class A members are the investors. And you can also have several different classes of Class A members. For example, if one investor puts in a lot of money and you want to give them special rights or special compensation, you can call them Class A1 members. Everybody else is Class A2 members, something like that. But generally speaking, they're going to be from the way I structure deals, they're going to be Class A members. And again, the Securities Act is implicated. But we can find an exemption as long as the rules Reg D are followed. Securities and Exchange Act of 1934 is implicated and satisfied only if all the sponsors, all the management team has a significant role. And then the Investment Company Act, I don't think it's, in my opinion, I don't think it's implicated because you're operating the deal. However, if you're doing a fund, there may be more questions as to whether you're an investment company. But again, if you're a fund who's directly owning the property or through a subsidiary is directly controlling the property, then you can rely on 3C, 5C. And then the Investment Advisor Act, also not implicated because you are operating real estate. You are not purchasing securities in another company. In this deal structure, it's pretty much the same thing. I just wanted to show, again, some people bring in these so-called capital raisers, and it's the same implication, same everything, except that the Securities and Exchange Act of 34, you just have to be really careful because if the SEC ever does audit you, they could find that to be problematic. And then a fund-to-fund situation, this is where this is actually, so for example, if you don't want to bring in a capital raiser into the management team, and I've actually structured one fund where the fund was only raising capital from fund of funds. I also call them feeder funds. But what a feeder fund is, or a fund of funds is it's a separate LLC that has its own investors, has its own manager, and that fund of funds will become a Class A member, become an investor in this syndication entity. And so basically all the, so you as the manager, you don't have to add anybody to your management team because they're going to be investing through their own fund. And so again, I set up a fund recently where they only raised capital through fund of fund, through fund of funds. So they said, hey, we're not taking any of our own investors into this LLC. We're only taking on fund of funds, and they were able to raise capital pretty quickly, pretty efficiently that way. So that's one way to sort of, I don't want to say circumvent, but that's one way to potentially comply with the broker dealer issue that you have with bringing in capital raisers, is if that so-called capital raiser is actually a fund of fund manager, then you can potentially avoid the trouble that you'd get into bringing them into the management entity. So that's actually one reason, that's kind of becoming a more popular structure for people who are good at raising capital, is the fund of fund structure. The problem with the fund of fund structure implicates all the other things. The Investment Company Act, you're definitely going to have to comply with, because now it's definitely an Investment Company Act thing. And you can't rely on 3C, 5C unless that fund of fund has significant management control rights of the syndication entity. But most fund of fund managers don't want those control rights. So they have to rely on the 3C1 exemption. In other words, they have to have 100 or fewer investors in the fund of fund. You also trip up the Investment Advisor Act. And I could tell you, in fact, I know probably at least one other attorney on here would give you a different opinion on how to treat the Investment Advisor Act when you're dealing with the fund of fund. And that is, so for me, I say, hey, you're not an investment advisor if you have a deal identified and you can give that sponsors team of that identified deal, we call it the master fund or the underlying fund. If you can give the information from the master fund directly to your investors rather than being that go-between, then you're not acting like an investment advisor. And so most of my clients who do fund of funds, I always recommend that you have a deal identified you have a deal identified, so you can say, hey, I'm going to be managing your money, investors, but I'm not giving you any investment advice. All the advice that you're going to get on this deal is going to come directly from the master fund. And so I have them provide the PPM and the operating agreement of the master fund. The other thing, though, you still want to look at some of and one of the reasons why I do that is because every state has different requirements for private fund advisors, which is what you guys would, if you guys fell into that category of an investment advisor, that's probably what you'd be considered. But yeah, every state has different rules. So for example, Idaho says that you can be a private fund advisor, but you can only take on qualified clients. In other words, clients that have a net worth of something like $5 million or more. Whereas a company like North Carolina says, hey, you can be you can be a private fund advisor to up to 15 companies before we even have to worry about anything. So, different states treat this differently. So I like to just avoid it altogether and just say, hey, my clients are not acting like an investment advisor because all the advice is coming from this master fund. They're not providing advice. They're only providing maintenance on their business to allow investors to invest. And so the last one that we'll go over is this what I'm calling a JV syndication. Some people also might refer to it as pref equity, but essentially it's where two people who are raising capital from investors are going to joint venture on a project. And you can do this again, if you have a fund where you're buying multiple properties, you can again set up an SPE and still create this similar situation. It would be just your fund and this other syndication entity can sort of joint venture on the SPE. And so again, all the same things are implicated. The difference is that, as an investment company, typically when you're joint venturing on a deal like this, both parties have some control rights in this SPE. They have, at the very least, they have, what might be considered customary decision-making skills. So when is the asset going to get disposed of? When are we going to refinance the property, et cetera? Or if we're going to refinance, all those major decisions would be voted on by the managers of both these entities. And because they have certain control rights that the SEC says, hey, if you have certain control rights, then it may look like you may be considered to have the benefit of a direct interest in real estate. You can now rely on 3C5C. Whereas in the fund of funds, unless you have control rights in a fund of funds, you can't rely on 3C5C. But in this situation, you can rely on 3C5C. So again, you're not limited to 100 investors, and you don't have to register as an investment company. And also, again, because if you have direct interest in the property and you have direct control rights, you're also not implicating the Investment Advisor Act, because you're not, again, advising on securities. You are managing real estate.